Welcome to the new season of GABWA's Legally Speaking. I'm Kenya Johnson.
And I am Laverne Lewis Gaskins. Legally Speaking is brought to you by the Georgia Association of Black Women Attorneys, GABWA. This season, Legally Speaking will focus on attorney development, covering topics that may help us all become better attorneys and grow in our diverse areas of practice.
Today, we're talking about lawyer discipline and professional responsibility. Have you ever had a bar complaint? We are happy to be joined with Paula Frederick, General Counsel of the State Bar of Georgia, to help us navigate through the bar complaint process and stay on the right side of our professional responsibility. Thanks so much for joining us, Paula.
I'm happy to be here.
Thank you so much for your time. Let's begin with your career path to becoming General Counsel of the State Bar of Georgia. Talk to us about your journey and how long have you been in this role?
Sure. I went to law school because I wanted to be a legal services lawyer. So it never occurred to me, I never even knew that a job like this one existed at the time. When I got out of law school, I worked for 6 years with the Atlanta Legal Aid Society, handling civil legal matters for poor people. And that was a nice place for me to be. I learned a lot about being a lawyer. I got a lot of litigation experience. But after 6 years, I got a little tired of the low salary, frankly, as well as, the work is stressful and high burnout. And so a friend, Mel Westmoreland, who was then a judge in Superior Court, had worked with me at Legal Aid and gave me a call and told me that they were hiring in the General Counsel's office at the bar. I really didn't know a lot about the job or the bar itself, but came over and interviewed and frankly was surprised when I got the job. I wasn't sure I would like it. We were prosecuting people. I'm not a prosecutor, but I found that I really did like it, and so spent a number of years prosecuting disciplinary cases. And then when my predecessor as general counsel retired, he really shepherded me along the way to applying for the job as general counsel, which adds in-house counsel duties to the other part of the job that I was already doing. So it's been 30 years that I've been at the State Bar now. I came in 1988.
Wow, that's fascinating. Let's spend just a few minutes talking about bar grievances. I think it's fair and important to note that the majority of lawyers never have a bar grievance, but lawyers should be proactive in their understanding of the grievance process. With that being said, please share some of the most common grievances that you've seen in your role as general counsel.
Well, Lauren, you're absolutely right. There are 50,000 lawyers licensed by the State Bar. The vast majority of them won't ever have a grievance filed against them. And lawyers, nobody goes to law school because they want to be unethical or dishonest, I always say. And so there are reasons that people get into trouble. But by far the biggest complaint that we get about lawyers involves lack of communication. So people don't like it when they don't hear from their lawyer on a regular basis. They don't know what's going on with their case. And frankly, obviously that causes stress. They don't know if the lawyer's abandoned them or if there's just nothing happening. And so the biggest complaint that we get is about a lack of communication. I don't know what's going on. That's not the most serious complaint that we get, because most of the time it turns out that nothing's going on. The court hasn't put the case on a calendar. The most serious kinds of complaints that we get involve conflicts of interest and then obviously criminal conduct, theft of funds, that kind of thing.
So Paula, tell us, if one should have a complaint filed against them, what is the process?
Well, first of all, the odds increase probably triple if you do family law, if you do criminal defense, or personal injury. Those are the areas of practice that we see the most. And so you are likely to have a grievance filed against you at some point if you engage in one of those sort of high-risk areas of practice. The process works by somebody filing a grievance against a lawyer. And we require that grievances be submitted on a form that we provide to people. So typically somebody will call and say, I'm having a problem with my lawyer. We'll talk to them about it. Most often we can figure out a way to get the lawyer's attention and they work things out without filing a grievance. But when they need to file a grievance, we send them the form, they complete the form and send it back to us. We have a different lawyer on duty every day, handling ethics hotline calls and reading the grievances that come in. There are about 10 new ones every day. The lawyer who's on duty will read the grievance and decide whether it warrants sending to the lawyer and asking for a response. So we screen grievances that way. We ask the lawyer to respond. When the lawyer responds, we send their response to the person who filed the grievance, ask them to add any information they want to add, and then one of the lawyers in the office reviews the file, which is basically the grievance, the response, any rebuttal, and decides if there's something else that we need that would help us determine whether the lawyer's got a problem under the rules of professional conduct or not. If so, we've got subpoena power. We can ask for copies of bank records. We can informally ask the lawyer to send us a copy of their correspondence or their client file. But we've got a lot of latitude in how we screen a grievance. At the end of the screening process, if we find that there's some merit, there's a possibility that the lawyer has violated the rules, we send the file to the state disciplinary board, which serves to, it's sort of like a grand jury. They investigate grievances. They meet monthly. They make a decision whether there's probable cause to believe that the conduct that's complained about is a violation of bar rules. And where there is, they make that probable cause finding. They send the case back to my office, and we file charges against the lawyer in the Supreme Court. The court appoints a special master to hear a case, and ultimately the court enters an order either disciplining the lawyer or not. Now, at every step, from the in-house screening to the disciplinary board to the special master process to the court, most cases are dismissed, pretty much, except for those last two steps. Most cases are dismissed along the way. But we do the investigation and make that probable cause finding is basically what we do.
So after the investigation and before the probable cause has been determined, how active is the attorney in the process? What happens if an attorney does not respond, or how important is it for an attorney to respond?
Yeah, unfortunately, we get a high percentage, I estimate 10 or 15% of grievances where we never hear from the lawyer. And the odds are obviously pretty high that you're going to get disbarred if you don't respond to a grievance. But most people know that if they do respond in the way that we've requested at each step of the process, there's probably an 80% chance that the grievance will be dismissed. At the beginning, we just ask the lawyer to send us a letter, not a legal brief, nothing very formal, and just tell us what happened. And most folks do that.
So what I'm hearing is that you must respond.
Please
no
respond,
matter what,
yeah.
please respond.
Yeah, and that's the most important takeaway. I hear what you're saying.
Right. And I think for our members of GABWA, you're sort of surrounded by this nurturing family that wants to see you succeed as a lawyer. And so hopefully people don't feel like they can't reach out to somebody else. If they can't open the letter from the bar, they know it's a grievance, they've been having trouble with the client, they can go to somebody else and ask for help. What we see with the people who don't respond is lawyers who are isolated, who don't have that friend or that nurturing group, and they just stick their heads in the sand and never respond. And that really should not happen to any member of this organization.
I agree. You know, all these cases aren't alike. You know, we have different levels of discipline for the cases depending on the infractions. And could you talk about those different levels of discipline? And also share with us whether or not there's any space, there's any room for mitigating factors, consideration of mitigating factors.
Sure, of course there is, and every case is different. It's part of the reason I enjoy what I do, frankly, is that there's a reason for every violation of the rules. And frankly, with women, a lot of times what I see is people who are overwhelmed with life. They've got responsibilities at home, they've got responsibilities at work, and they may be shouldering, frankly, more than their share of responsibility in both places. And so, sometimes it's as simple as I got sick and I was unexpectedly in the hospital and my clients didn't know where I was because I practiced by myself. Obviously, that person is trying to do the right thing, is just sort of overwhelmed by their life and their illness, and we're going to give them a break because of that. I mean, the rules of professional conduct typically require some level of intent to violate the rules before you're really talking about serious misconduct. But an accident or an isolated incident of misconduct isn't going to get you disbarred. The lowest level of discipline is a formal letter of admonition. And, that's the first level that really is discipline. We also can dismiss a case and send the lawyer a letter of instruction, which is just information about what you might do differently if you're ever faced with the same situation again. But it's not discipline. It's meant to be helpful to the lawyer, although I think a lot of lawyers get it and don't want to read it. So formal admonition is just a letter that's sent to the lawyer saying, we found that you abandoned this case, but we found mitigating circumstances. You were ill, you weren't able to let the client know, and so we've given you this lowest level of discipline. Next, there are a couple of levels of reprimand where the lawyer literally has to appear at a meeting of the disciplinary board and stand there while the chair of the panel reprimands them for their misconduct. Basically reads a reprimand to them, what you did wrong, what you should have done, what rules you violated. Those two levels of discipline are confidential, which means they don't get published anywhere and people don't know about them mostly. The other levels are public, and they are noted on the bar's website. So there's a public reprimand, and then various levels of suspension from practice, and then obviously the ultimate sanction is disbarment, where you cannot practice anymore. If you're suspended, it can be for anywhere from a month to 5 years, basically. And suspension is for pretty serious cases where lawyers are addicted to something, or alcoholic, or stealing money, or have a pattern of misconduct in terms of abandonment and that kind of thing.
Well, Paula, it's so interesting to know that there are so many levels of investigation, discipline, and review for all attorneys facing ethical complaints. And thank you again for always being a resource for attorneys throughout the years. So can you tell us, are there any tips or advice that you have for practicing attorneys to steer clear of any ethical review?
Yes, and once again, sort of staying in the company of lawyers is a helpful thing because we need to help each other. And particularly if you're a solo practitioner, just to have a plan B. If I get hit by a MARTA bus on the way to court, who's going to tell my clients? How are they going to know? Who's going to notify the court? And I encourage people to come up with a buddy system kind of a practice where they've got someone else who can fill in for them occasionally if that's needed. But watching for signs of burnout, signs of stress, lawyers are now realizing how much of the disciplinary process has roots in the lawyer's wellness. And so you'll hear the bar talking about wellness a lot now, just sort of maintaining physical and mental, in particular mental wellness means that you're better able to serve your clients. Every now and then I hear from a lawyer who's just screwed up. Something happened and a check bounced out of their escrow account. And for me, reaching out is a very important part of how to deal with this. If you're at a loss as to what to do, the lawyers in my office will talk to you even while you have a grievance pending, because we'd rather, our job is to protect the public, not just to punish lawyers. And so we'd rather figure out, oh my God, what do we do? This lawyer fell victim to a scam and their escrow account was cleaned out and they owe this money to clients. How can we fix this? So I do think that by reaching out either to other lawyers or to the lawyers in my office, you'll find that people are willing to try to help. And nobody just wants to disbar lawyers for fun, really. It's a sad thing to have to do.
Well, that is certainly great information and great tips to know. Thank you so much, Paula, for joining us today. We appreciate being able to use you continuously as a resource. If an attorney has an ethics question, where do they call or who can they contact?
We have an ethics hotline here at the bar. One of the 10 lawyers in the general counsel's office staffs it every day. You can send questions through the bar's website by email, which a lot of people like to do because then you've got a record of what the advice was. Or you can call just during normal work hours and talk to one of the lawyers on duty about the situation. I always have to tell people, please call before you do it. I have a lot of people who call and say, I just did this, tell me I didn't break the rules. It's like, why didn't you call before you did anything? And we're happy to point out the rules that apply and give you our best advice about what it is that you ought to do.
Thank you so much for being on our show today, and thank you so much for this super information. To learn more about today's guests or more about the Georgia Association of Black Women Attorneys, please visit us at GABWA.org, GABWA.org.
And we'd love to hear from you and get ideas for our next Legally Speaking show. You can follow us on all social media platforms at GABWA and Legally Speaking GABWA. Thanks for joining us.
This concludes our edition of Legally Speaking. Thank you for watching, and we will see you next time.